Hello, everyone. We're going to continue reading the United States Constitution. I'm going to a different document this time. I'm taking this document directly from the Senate, and they include their notes on there. So I will read what the Constitution says, and I will compare it to what the Senate has to say. I'll start at Article 1, Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. The Senate note says, Section 8 begins the enumerated powers of the federal government delegated to Congress. The first is the power to tax and to spend the money raised by taxes, to provide for the nation's defense and general welfare. This section was supplemented by the 16th Amendment, which permitted Congress to levy an income tax, which we will cover later. To borrow money on the credit of the United States. Congress can borrow money through the issuance of bonds and other means. When it borrows money, the United States creates a binding obligation to repay the debt and cannot repudiate it. Very interesting. I've always wondered why the United States even bothers to borrow money that way, the way they do right now. And when the United States first started, the only money that they really collected were on import duties. They were not taxing citizens back then. And people will say, well, that's why the United States was such a poor country for so long. But the reality is government does not make money. Government steals money from somebody. It's robbing Peter to pay Paul. So you do not want government collecting large amounts of money, because government is ineffective, government is inefficient, and government usually is decided by the rich and the powerful, the people with the influence. So people who just want to live their lives, they usually do not benefit from big government. To regulate commerce with foreign nations and among the several states and with the Indian tribes. The note from the Senate reads, the Commerce Clause is one of the most far-reaching grants of power to Congress. Interstate commerce covers all movements of people and things across state lines, and every form of communication and transportation. The Commerce Clause has permitted a wide variety of federal laws, from the regulation of business to outlawing of racial segregation. The Indian Commerce Clause has become the main source of power for congressional legislation dealing with Native Americans. Now, this has gone to the Supreme Court, and they're right. This is a far-reaching document, and they've made it so. Some people would argue that the federal government has overstepped their powers by creating rules, regulations, and laws where the Constitution did not grant them. To establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. Senate note comments. Acts of Congress define the requirements by which immigrants can become citizens. Only the federal government, not the states, can determine who becomes a citizen. Bankruptcy laws make provisions for individuals or corporations that fail to pay their debts. To coin money, regulate the value thereof and of foreign coin, and fix the standard of weights and measures. These clauses permit Congress to coin money and to issue paper currency. By extension, under its ability to enact laws necessary and proper to carry out these powers, Congress created the Federal Reserve System to regulate the nation's monetary supply. I contend that that is a violation of the Constitution. Constitution does not give power to third parties or foreign parties to handle the United States money supply, to provide for the punishment of counterfeiting the securities and current coin of the United States, to establish post offices and post roads. Senate comment as follows. The postal powers embrace all measures necessary to establish the system and to ensure the safe and speedy transit and prompt delivery of the mail. Congress may also punish those who use the mail for unlawful purposes, and they do. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. And this is where copyright and patent protection of authors and inventors are authorized by this clause, although it uses neither word. But I will say, these have, I don't know the rules and the laws off the top of my head for copyright and patent protection, but I'm pretty sure it's a copyright or a patent is 20 years, and I don't remember what it is a copyright. But you're only supposed to get an extension on these when you create new work off the old work. And powerful companies like Disney have unlimited copyright protection of Mickey Mouse and other characters and stories because they have the budget and the means to do so. So I always felt that there was not an equal rule of law applied under this section. Again, it comes down to whoever has more money and more power tends to make the rules apply to them differently. To constitute tribunals inferior to the Supreme Court. Senate note, the Constitution provides only for a Supreme Court and left it to Congress to create lower, inferior courts and to set their jurisdictions and duties. To define and punish piracies and felonies committed on the high seas and offenses against the laws of nations. Congress note, every sovereign nation possesses these powers and Congress has acted under this authority from the beginning. I just want to comment on the court system. I heard a very good comment recently that I'd heard years before. And its observation was that the more rules and more laws a country has, the more corrupt it is. Because people turn to corruption to get around these useless rules and regulations. And the United States now, you can see that they have a rule and a regulation for everything, and it grinds a country to a halt. And it drives home that there really has to be very few laws compared to what we have now. But that's another topic for another day. To declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. To raise and support armies, but no appropriation of money to that use shall be longer term than 2 years. To provide and maintain a navy, to make rules for the government and regulation of the land and naval forces. The Senate adds notes as follows. The war powers are defined here and in Article 2, Section 2. Congress declares war while the president wages war. However, presidents have committed U.S. forces leading to conflict without a congressional declaration of war in Korea, Vietnam, and other places, provoking national argument over the meaning of these powers. Congress's control of funding the military provides another check on the executive branch. The other thing that is a skirt around the rule is this section that says no appropriation of money longer than term of 2 years. So they will provide contracts much longer than that, and they will set up payment systems a lot longer than 2 years, which is a violation of the Constitution. But they do it. They do it. And I'm sure they have some rule or regulation that says it's not a violation, but it is. Because all we know how to do in this country is is provide for the military-industrial complex. So of course they're going to skirt that law. The other thing is grant letters of marque and reprisal. So you can see that we are now turning to these private contractors. Halliburton had no bid contracts. Now you have certain defense contractors and mercenaries who are fighting these wars for the United States now. To provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. Senate writes, under these provisions, the right of the states to maintain a militia, including what is now the National Guard, is always subordinate to the power of Congress. In 1795, Congress first gave the president authority to call out the militia to suppress insurrections. Presidents employed this power to enforce federal law during desegregation disputes during the 1950s and later during civil disturbances in various cities during the 60s. To execute exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as may, by cession of particular states and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the states in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. This clause, according to the Senate note here, enables Congress to govern the District of Columbia. Congress has now delegated that power to a locally elected government subject to federal oversight. Congress also governs forts, arsenals, and other places obtained from the states for the federal government's purposes. If we start hearing about trying to make the District of Columbia a state, it will be very interesting to see how the U.S. Constitution interprets those movements. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by the Constitution in the government of the United States, or in any department or officer thereof. The Elastic Clause enlarges legislative power by enabling Congress to use any means it thinks reasonable to put these powers into action. This clause also authorizes Congress to enact legislation necessary to carry out the powers of the other branches, for example, to organize and reorganize the executive branch. Well, that's not the way I read it. So the Senate, this is where we're going to have some battles going forward. Article 1, Section 9, the migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808, but a tax or duty may be imposed on such importation, not exceeding $10 for each person. This obsolete provision was designed to protect the slave trade from congressional restriction for a period of time. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. And there you go. They can restrict habeas corpus anytime they want now because they've passed the NDAA and the Patriot Act, which are not constitutional. You'll hear some people out there say that the United States entered a state of martial law back during the Civil War, and we're still in a state of martial law. In fact, there is what's called the peace flag and the war flag. And supposedly the flag that we're using now with the stars and the stripes is a war flag. And I've seen pictures of the peace flag, and it looks nothing like a flag that most people have ever seen. It looks more like a banner than a flag. But these are some of the things that we really have to be careful of, because once certain rules are imposed upon people and a current generation accepts them, the next generation will always believe that that's the way things were, when that's not the case. We really have to get back into being ready to fight and contest when the Constitution of our land is obfuscated, when our Constitution is ignored or violated. And here's a perfect example. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion, the public safety may require it. Habeas corpus is a judicial device by which jailed people may require their jailer to justify their imprisonment to a court. It's a fundamental safeguard of individual liberty, and the Supreme Court has interpreted it to give federal courts review over state court convictions and to enforce federal constitutional guarantees. It is generally accepted that only Congress has the power to suspend habeas corpus. President Abraham Lincoln's suspension to the right during the Civil War met with strong opposition. And what this does not say is it does not say that habeas corpus specifically says that somebody shall be brought before the court in a timely manner for a hearing to determine whether it's a lawful arrest or not. The NDAA and the Patriot Act actually now allows our government, in their eyes, to black bag Americans, to take away our right, to basically put us in a cell or send us to Guantanamo or one of these prisons in the Eastern Europe or wherever they have them now, and just hold us there indefinitely without recognizing process to our rights. Very dangerous times. And it's the old saying, I'm sure everybody has heard this meme where they say they came for the Jews and nobody said anything. They came for the newspaper guys. They never, and then they came for me because nobody ever stood up and said no. So get ready, folks. Either you're going to have to become liches who conform to whatever you're told. And Plato's 5 regimes have already predicted in his writings that a democracy morphs into a tyranny. Because what happens is exactly as Ben Franklin warned. People give up their freedom and their liberty for security, and they will turn to a dictator. No bill of attainder or ex post facto law shall be passed. A bill of attainder is a legislative act declaring the guilt of an individual or a group of persons and punishing them. Only the courts may determine whether one has violated a criminal statute. An ex post facto law declares an act illegal after it has been committed or increases the punishment for an offense already committed. No capitation or other direct tax shall be laid unless in proportion to the census of enumeration herein before directed to be taken. Senate note, direct taxes are poll or head taxes and taxes on land. The Supreme Court once held that income taxes were unconstitutional direct taxes, a result overturned by the 16th Amendment. We'll get to that later. No tax or duty shall be laid on articles exported from any state. To prohibit discrimination against any state or regions, Congress cannot tax goods exported from a state to foreign countries or those that move between states. Congress cannot favor one state against another while regulating trade. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bound to or from one state be obliged to enter, clear, or pay duties in another. While it's not ships, trucking is regulated, and they do have weigh stations in various states. They find a way to regulate and tax that way. They may not call it this, but they'll find violations and exact their pound of flesh that way. No money shall be drawn from the treasury, but in consequence of appropriations made by law, and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. Well, this is a joke. This is a joke. They lie through their teeth. How many trillions are unaccounted for? How many trillions have been printed by people other than the treasury that are out there floating around? You've got euro dollars, you have the Fed, you have black budgets that have monies that are not appropriated or accounted for. Donald Rumsfeld came on the day before 9/11 and said, well, we've lost $1 trillion. We can't find it. The spot in the Pentagon that just happened to get destroyed was the section that was responsible for that investigation. So all those files just happened to get destroyed. What a coincidence. Not. And then Building 7, the building that was not hit by a plane, the only building ever made of steel that fell from an office fire, more likely charges that were exploded, that brought down a controlled demolition. There was a court case going on regarding, I don't remember the exact details of the court case, but again, files were destroyed. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept of any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state. This clause was designed to end the aristocratic tendencies that the American Revolution had been fought against. Federal officials must turn over to the government all but minimal gifts from foreign nations. Section 10. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. These provisions protect national powers from state incursions. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws, and the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress. The Congress note, states may not interfere with the international trade of the United States. So Section 10 is basically spelling out, because if the Constitution does not specifically grant the federal government powers, then those powers do not exist. They can't come in and make up rules and regulations that are not specifically spelled out by the Constitution that gives the federal government that power. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops, or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded, or in such imminent danger as will not admit of delay. This is the note from the Senate. States cannot levy tonnage duties, which are taxes charged for the privilege of entering, trading in, or remaining in a port. States may come together to work on common problems such as pollution of a river passing through several states, but the agreements or compacts they reach are subject to congressional consent. That is the end of Article 1 of the United States Constitution. Article 2, Section 1. The executive power shall be vested in a President of the United States of America. He shall hold his office during the term of 4 years, and together with the Vice President, chosen for the same term, be elected as follows. Each state shall appoint in such manner as the legislature thereof may direct a number of electors, equal to the whole number of senators and representatives to which the state may be entitled in the Congress. But no senator or representative or person holding an office of trust or profit under the United States shall be appointed an elector. The electors shall meet in their respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all the persons voted for, and of the number of votes for each, which list they shall sign and certify, and transmit sealed to the seat of the government of the United States, directed to the President of the Senate. The President of the Senate shall, in the presence of the Senate and the House of Representatives, open all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the president, if such number be a majority of the whole number of electors appointed, and if there be more than one who have such majority and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for president. And if no person has a majority, then from the 5 highest on the list, the said House shall in like manner choose the president. But in choosing the president, the vote shall be taken by the states, the representatives from each state having 1 vote. A quorum for this purpose shall consist of a member or members from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the president, the person having the greatest number of votes of the electors shall be the vice president. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the vice president. Now the Senate notes. This clause provided the title of the chief executive and defined the term of office. It says nothing about re-election. George Washington established a 2-term tradition, which was not broken until FDR won a 3rd and 4th term. The 22nd Amendment now limits presidents to 2 terms. We should probably revise the 22nd Amendment for additional term limits. The Constitution established an electoral college as a compromise between direct popular election of the president and election by Congress. The method of selecting electors was left to the states. Electors are now chosen by popular vote. This clause was superseded by the 12th Amendment after the election of 1800, in which Thomas Jefferson and his running mate, Aaron Burr, received identical votes and both claimed the office. After many votes, the House of Representatives chose Jefferson, and soon thereafter the amendment was speedily approved. The Congress may determine the time of choosing the electors and the day on which they shall give their votes, which day shall be the same throughout the United States. So isn't it interesting that in this election they're talking about votes coming in weeks in advance and weeks after? So is that a violation of the Constitution? Well, according to this, it is. We will find out when we read the other sections if there are any amendments that allow that to change. Congress has enacted legislation requiring that presidential elections, the selection of electors, occur on the Tuesday following the first Monday in November every 4 years. Electors gather to vote on the Monday after the second Wednesday in December. The 2 houses of Congress convene to count the electoral ballots on the following January 6th. No person except a natural-born citizen or a citizen of the United States at the time of the adoption of this Constitution shall be eligible to the office of President, Neither shall any person be eligible to that office who shall not have attained to the age of 35 years and been 14 years a resident within the United States. Senate note: this clause requires that in order to take the oath of office, a president must be 35, a resident within the United States for 14 years, and a natural born citizen. This last requirement raises the question of whether someone born to American parents outside of the United States would be eligible to hold the office. Interesting that they don't answer that, because in the election between Obama and McCain, everybody was focused on Obama being born supposedly in Kenya instead of Hawaii, which is what his doctored birth certificate claimed. Nobody seems to remember that John McCain was born in Panama when his father was in the military. And people will be like, well, that was technically United States territory. Well, not really. But it does raise the question, and these are the loopholes. And that's the whole amendment process that was designed by the Constitution. If there are loopholes that need to be tightened up, then it provides a provision for closing those loopholes, but it doesn't make it easy. In case of the removal of the president from office, or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the vice president, and the Congress may by law provide for the case of removal, death, resignation, or inability, both of the president and vice president, declaring what officer shall then act as president, and such officer shall act accordingly, under the disability be removed, or a president shall be elected. The 25th Amendment superseded this clause regarding presidential disability, vacancy of the office, and methods of succession. The president shall, at stated times, receive for his services a compensation which shall neither be increased nor diminished during the period for which he shall have been elected, and he shall not receive within that period any other emolument from the United States or any of them. To preserve the president's independence, Congress can neither raise nor lower the president's salary during his term, nor can a president accept any other pay. But you can well be assured that Congress will continually raise the pay because they want to raise their own pay. Before he enter on the execution of his office, he shall take the following oath or affirmation: I do solemnly swear or affirm that I will faithfully execute the office of President of the United States, and will to the best of my ability preserve, protect, and defend the Constitution of the United States. The Constitution prescribes the oath that presidents must take. By contrast, Congress by statute created the oath taken by other federal officials, including the Vice President. Article 2, Section 2. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of several states when called into the actual service of the United States. He may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of their respective offices, and he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. As Commander-in-Chief, the President controls the military forces. Presidents have also cited this power as extending to their control of national and foreign policy in war and peacetime. Congress may not restrain the President's power to pardon except in impeachment cases, which is interesting because Nixon resigned before he was impeached, and then he was pardoned by Gerald Ford when Ford became president. Very interesting. If Congress had impeached Nixon, then he would not have been pardonable. The president shall have power by and with advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur. And he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers, and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers as they think proper in the President alone, in the courts of law, or in the heads of departments. The Constitution gives the Senate a share in foreign policy by requiring Senate consent by a 2/3 vote to any treaty before it may go into effect. The President may enter into executive agreements with other nations without the Senate's consent, but if these involve more than minor matters, they may prove controversial. The President must also submit judicial and major executive branch nominations to the Senate for its advice and consent. The Constitution makes no provision for the removal of executive officers, which has remained largely at the discretion of the President. The President shall have power to fill up all vacancies that may happen during the recess of the Senate by granting commissions which shall expire at the end of their next session. When the Senate is not in session and therefore unable to receive nominations, the President may make recess appointments. The Senate will then consider the nomination when it returns to session. And presidents many times will wait till the Senate goes on leave to appoint people for that specific reason, to get them in there without an immediate vote. Article 2, Section 3. The President shall from time to time give to the Congress information on the state of the Union and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses, or either of them, and in case of disagreement between them, with respect to the time of adjournment, he may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. The duty to deliver to Congress an annual address, known as the State of the Union message, is the basis of the President's legislative leadership. Presidents have frequently summoned Congress into extra or special sessions, but they have never exercised the power to adjourn Congress. The law enforcement function has been a source of the President's control over the executive branch. However, the laws that the President is to execute are the laws that Congress passes, and those laws constrain as well as empower the chief executive. Section 4. The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Impeachment is the ultimate power of Congress to deter and to punish abuse of power by officers of the executive and judicial branches. Federal judges constitute the greater number of impeached and convicted officers. President Andrew Johnson won acquittal by a single vote, and President Richard Nixon resigned before he could be impeached. Well, obviously, this is a very old document, or they just chose not to include Clinton in here. And of course, Trump is in that category as well. Unfortunately, politics often play a role in these things. Okay, folks, I'm going to call it there. I'll pick up at Article 3 next time. Please leave your comments, questions below.